So you got hurt pretty bad on the job in Virginia or North Carolina. You had an award or an accepted claim for certain covered body parts, and you're receiving your weekly comp benefits. Now your orthopedic surgeon or neurosurgeon says he wants to do surgery on you, or some other treatment that's been recommended by your doctor. Or your doctor says you have permanent restrictions from your injuries. Now suddenly, out of nowhere, either your attorney tells you, or if you don't have one, you get a call from the adjuster, or the defense attorney says that you got to appear for something called an independent medical examination, or an IME, with a doctor who you've never heard of at a certain time or place. The doctor might even be some distance away from your home. Now, what the heck is going on there? Do you have to appear for this exam to this doctor you've never heard of? And what happens if you don't? My name is Joe Miller, workers' compensation attorney in Virginia, North Carolina, personal injury attorney in Virginia, North Carolina. And that's what we're here to talk about today, which is independent medical examinations, commonly known as IMEs. Okay? So the short answer is yes, you got to appear, you have to appear for the independent medical examination that is ordered by the defense. And in some cases, you may have to attend more than one. Okay? This is because under the law, whether it's in Virginia or North Carolina, the defense really has the right to send you to an independent medical examination with a doctor of their own choosing who is of the same specialty as your authorized treating doctor. So for instance, let's say that you got one doctor for your back and another doctor for your ankle. Why would that be? Because as we know, there are doctors who are specialists, and some doctors, you might have a doctor who is a foot and ankle specialist and another doctor who's a spine specialist. So in a case like that, if there were things going on with both of those body parts that they wanted second opinions on, the defense would be within their rights to go ahead and ask you to attend two different IMEs with two different specialists that match up with your doctor's specialists. So what happens if you refuse to attend the independent medical examination? So in Virginia, it's pretty simple and extremely harsh. As I've explained before in other videos, Virginia has what I believe is an extremely unfair system in this regard. All the defense attorney has to do is file a paper with a commission that says you didn't appear at the IME, refuse to attend the IME, and that's pretty much it. At that point, your workers' compensation benefits will cease on that day without any hearing, nothing. Yeah, your attorney gets to respond, but typically you've created an issue now at that point, and it's going to go to hearing. And I'm not sure what your defense would be except to go back and say, okay, I give up. I'm going to attend the IME. So, sure, and the hearing's going to be several months down the road. Meanwhile, you get no benefits at all. What about North Carolina? Only slightly better. You do get a hearing fairly quickly. They would probably file what's called a Form 24, which means basically a motion for summary judgment, meaning throw out your case. And your attorney or you have 14 days to respond to that. And then you get a little hearing on that issue. But they're going to cut off your benefits if you don't agree to attend the IME. You get a notice to attend an IME unless there's something wrong with it, like it's the wrong specialist or something like that. You got to go. It's not fun, and it's probably not going to help your case, but they're within their rights to do it. So that brings us to our next question. Will the defense IME or the independent medical examination always hurt your case? You can't imagine if the defense is ordering it that it's going to be something helpful, because, it's a doctor that's hired by the defense, right? So most of the time, in my experience, especially in Virginia, the answer really, is the workers' comp insurance company will try to have it hurt your case, but whether it will really depends on many things. First of all, what's the purpose of the IME? Sometimes it is to take out or remove or block a claimed body part from coming into the case, or prevent that body part, from being added to your claim, for instance. Let's say that you had, a lot of prior treatment to your back before your accident. You've gotten under an award for other body parts, let's say, your ankle, your neck or something like that, but you're still claiming, your back really got aggravated in the accident. And they're saying, you want to add that to your claim. And they're saying, no, we're not going to allow that. Matter of fact, and your doctor says, well, I think it's related or partially related. It was aggravated by the accident. And the defense says, all right, well, we want to get an IME on your back. So what are they going to do? In that situation, what they're going to do is probably hire and get an IME doctor who's going to do an extremely thorough review of your entire medical history and going back as far as they can get away with, okay? And they're going to come out and they're going to subpoena all your records from God knows when, and they're going to come out with a very detailed report, which may very well say that, as to the lumbar spine, for instance, even if it was aggravated by the accident, which you may or may not say, it causes you no disability now. And if you do have disability now or any problems from it, that all came from what pre-existed or was before the accident. And so in that scenario, it's not going to be enough for your treating doctor just to say, well, I believe this comes from the accident, in my opinion, with a reasonable degree of medical certainty. Magic words. Okay, we've talked about in another video how you got to have the magic words, right? He's also going to have to come out with a very detailed report. Now, before I go further, I just want to say one thing, but you really should know that is helpful. 95% of the time, right, the commission is going to go, and especially in Virginia, the commission is going to go with the opinion of your treating doctor. Look, your treating doctor has been seeing you all along and seen you many times, may have performed surgery on you, very familiar with your condition. The IME doctor has seen you one time. But if the IME doctor is very persuasive in his or her very, very detailed report and cites many records and to say why this is not related or why this is all pre-existing and nothing is coming from it now, a simple, just quick opinion letter from your doctor is not going to do the trick. Your doctor is going to have to look at that IME report in detail, write his or her own report in detail, and rebut all the things that doctor says. Otherwise, there's a good chance the commission's going to go with the independent medical exam doctor's opinion. If you're able to get your doctor to do that, if you get a report like that, one of these long, well-reasoned, very detailed, scathing reports that say none of this is related or whatever, you'll likely prevail, assuming that your treating doctor disagrees with what the IME doctor says and suggests that whatever you're claiming is related to the work accident. So that's one purpose of an IME, really an attack on any additional claims you may make or even your initial claim, right? What other kinds of doctors are independent medical exam doctors? Again, it depends on the purpose of the IME. If it's to discredit or take out of the case or prevent you from adding something, it's probably going to be one of these go-to guys. These doctors do many of these IMEs routinely, and they do a pretty good job of making you and your medical history look pretty bad. But that's not always the case. I've seen other kinds of defense independent medical exam doctors, the defense where they don't take that approach. For instance, let's say that your doctor has a recommended procedure or surgery that he or she wants to do on you on an awarded body part. Maybe the defense simply isn't sure if this procedure is really medically necessary. Maybe they don't trust your doctor 100%, and they simply want a second opinion before they plunk down thousands of dollars to pay for that surgery, okay? So many times in that situation, they're not going to refer you to a hack. They're going to send you to a more reputable local surgeon who will take an honest look at, the medical file and give an honest opinion as to whether you really need that surgery or other procedure. And they're generally not going to nitpick or write a report to discredit your doctor. And in those types of cases, I would say that more often than not, that IME doctor is actually going to agree with your doctor that you probably need the surgery. They might have some slight modifications as to the procedures that need to be done, but at that point, the carrier is, if you get that kind of report that's helpful, they're going to go ahead and give your surgery a green light. But what if the IME doctor does not support the surgery? Again, we go back to this notion that 95% of the time, the commission's going to go with your treating doctor. However, again, depends what kind of report they write. If they go ahead and pay for this hack report that's just, out to discredit you, your doctor needs to respond in kind, meaning also with a very detailed, well-reasoned report. Otherwise, it's not going to make it. So far, we've been talking about defense IMEs. What about you? Don't you have the right to a second opinion? In the Virginia workers' comp case, the answer is, look, really, you can go to any doctor you want to anytime. The problem is the defense doesn't have to pay for it. The insurance company doesn't have to pay for it. So if you can convince, if your health insurance doesn't have a problem with it, if you can get your health insurance to pay for it, yeah, you can go see a doctor if you want to. But I would do it. Of course, if you have an ongoing case, make sure you talk to your attorney. If you don't have one, I would suggest you speak to an attorney about whether it's wise to do that. If your doctor has you on a certain course of treatment that's heading you toward a good resolution to your claim, there is really no reason to go see another doctor. However, this doctor is not treating you right, not giving you the treatment you need, that may be an option for you. There is no official way through the commission to get an independent medical examination in Virginia. In North Carolina now, you do have the right, unlike Virginia, to get your own independent medical examination paid for by the defense, as a matter of fact. And you can either do it by agreement or you can do it by motion with the other side. Most of the time, we've been able to agree on who this doctor is going to be. Obviously it needs to be the right specialist for what you're dealing with, whatever your condition is, whatever your injury is. And if you have an attorney, you should only do that in consultation with your attorney. Just because you know a doctor, right, doesn't mean that that's going to be the right doctor for your condition. Let's go back to this defense IME. Let's say you get called up to one of these defense IMEs. Now that we've established that you can't escape it, how should you conduct yourself when you attend this IME? So the main thing, especially insofar as how you behave and how you appear, is to be consistent, okay? Don't think you can fool the independent medical examination doctor. They've already got a little bit of a bias against you if it's one of these things where they're trying to keep certain parts of your claim out, right? So I've heard of folks walking to the defense IME doctor with a cane, or something like this, limping, whatever, either with or without a cane. And then later, as they walk out to their car, they kind of ditch the cane and just walk it normally. Of course, the IME doctor's taking a peek out the window, or his secretary or nurse is, and there you are walking normally. They are going to burn you with that. Okay, and that's going to go in their report. I can guarantee it if they see that. And I've seen that more than once. So that's all they need to call you a liar, a faker, a malingerer. You don't want that. Okay. So what else? Being discourteous, being argumentative, being nasty to the IME doctor. Don't be antagonistic. There's no reason for that. He was hired to do a job. If they dislike you because you're a jerk, to him or his staff, you're going to make the IME doctor's job much easier as he tries to discredit you. Also, any kind of failure to report or deny previous injuries that are obviously in the medical records also makes you look bad, makes you look like a liar. Another thing that sometimes happens in these IMEs that to watch out for, occasionally I've seen actually an IME doctor say, even a defense IME doctor say that, you're a candidate actually for surgery for this condition, even if your doctor says you're not. And at that point in the examination, in the independent medical examination, the defense doctor may ask you, hey, would you go through with this surgery if it were recommended? And the incorrect answer, wrong answer, is, oh no, I don't want any surgery. Okay, don't say that, even if you really don't say it, because you just reduce the value of your claim by saying that. The correct answer is, okay, doctor, if you think it'll help me, I'll certainly discuss it with my family and my treating doctor. That's the answer. You're going to talk about it, with them. You don't have to give an answer then. You don't have to answer yes or no to that question. Just tell them, I'll think about it. So what that does is buy you time, even if you don't want the surgery. So why would you tell the defense that? Why would you not tell them that? It's better to let the defense think you might want it. Why? Because now the insurance company's got to worry that, they've had their own doctor say you need surgery and they might have to pay for a surgery. So they're more likely to offer you more money at settlement if they think they have to pay for surgery. If you say, no, I don't want that under any circumstances, you've just taken that money out of the case, right? So remember, everything that you tell the IME doctor, or really any doctor that you see in your case, can be put in the report, which means the defense lawyers, the insurance company, the insurance adjuster can see it. So don't see anything you don't want the defense attorney to read, right? Finally, there may be some papers that you have to sign. I've seen this happen before in the independent medical exam doctor's office before your exam. Now, one of the standard papers I've seen some IME doctors try to have the patient sign are ones that say that you are ultimately responsible for the bill for the exam. You don't have to sign that and should not sign that. I think it just happens because it's a standard paper. They think you're a patient. You're not a patient. Okay, when you go to an independent medical exam, you are not a patient of that doctor at that point. You're just there at the behest of the defense. So you don't have to sign any paper. You're not responsible for any of the cost of that examination. I hope that what we said today about independent medical examinations has been helpful for you. If you or a loved one have been injured in an accident at work, in Virginia, North Carolina, please don't hesitate to give us a call. We're happy to talk about your case. Meanwhile, Joe Miller wishing you a blessed day. Joe Miller out.